Okay. Well, thank you very much.
Javier, I'm afraid you're on mute.
Oh, I start again. So no, I was making a mistake. Thank you to all of you, to the audience, to the people who are in Spain, and to my friends who are in Sweden. And I am so happy to replace the president of the Madrid Center of International Arbitration, a newly born entity in the world of arbitration, and especially because they have accepted to join the SCC, historic arbitration entity from Stockholm, and to organize a joint meeting. A joint meeting who looks really very interesting, as you will notice later on. And I was expressing my gratitude and satisfaction because as a former ambassador of Spain to Sweden, I enjoy very much witnessing the success by the SCC, presided at the time by the Secretary General, Magnet Magnusson, and now by my also dear friend and my friend, Kristin Campbell-Wilson. So when I was an ambassador, I mean, one of the most interesting meetings I ever met and I ever had was a dinner organized by the SCC to celebrate the 100th anniversary of the Stockholm Chamber of Commerce. And then when I met these two wonderful women who were doing an extremely powerful job from the SCC. So once I have expressed my satisfaction, I also have the pleasure of meeting through the screen some of our best experts from Madrid and from Sweden who are going to talk about two very interesting topics. In fact, tell you the truth, both topics were perhaps, according to me, the main issues discussed in our last two Spanish events. We have once a year, I mean, we are not the most powerful country in arbitration, but we do our job. And there was one, the open, I mean, in September, we had the Spanish, there is a club of international Spanish arbitration, and we held an annual Congress. And then in October, we had open arbitration. And in those two events, the main topics were, perhaps according to me, I was just a listener, a follower, are exactly those topics we are going to discuss. We are going to discuss first digitalization, which is of course a very extremely important issue, and then we are going to discuss energy dispute. Energy dispute have a lot to do with Spain. We have been under many arbitration cases as facing very powerful entities who have expressed their not the satisfaction with some modification we introduced in our legislation. So we have suffered this experience, which is very powerful, very interesting for us. So, and this for discussing these two issues, we have four very well prepared experts. We are going to organize according to, I mean, we agreed, the five of us, to organize this in the best way. I'm going to stop talking immediately, and I'm going to start with the first panel, which will be dealing with digitalization. For 25 minutes, they will have all the time to express their point of view on this issue, where I know that Kristin Campbell-Wilson is very powerful because she has been behind as the number 2 of the SCC at the time, behind two very ambitious programs, which had to do with the SCC platform and especially with the SCC Express. So she will have many things to tell us how SCC managed from Stockholm to face, I mean, before the pandemics, SCC was ready. So we have followed, and I learned from Melanie, who is the number 2 and the most interesting person behind the Madrid International Center of Arbitration, that in fact they had followed SCC experience, and in fact they have joined in some approaches to the issue and in some platforms. So it will be very interesting for us to see in which way Madrid and Stockholm are working in the same technological world. So, and after that, we will have the dispute, and I will, at the time, I will introduce both panelists. I want only to add that, as you know, Kristin has a long experience as the SCC. She has been the number 2 for many years, and so she is really an experienced lady in this. She's also an experienced lady in another aspect which I admire very much. Is being dealt with by the SCC, which has to be with green arbitration. And I will have to remember Anne Magnusson, her friend, who has just left SDC, and she has started a new challenge in the area of climate change arbitration. But today she is going to devote, I mean, perhaps there will be an opportunity to talk more about climate change, but she's going to especially explain us how they have managed to make use of technological resources to improve the wonderful job being done by SCC. And Melanie, who is just arrived, so we are moving from a very historic arbitration entity in Stockholm to a very new institution in Madrid. And I would like to express to you my satisfaction, because from the time I was ambassador to Spain, Spanish ambassador to Sweden, I learned that one thing we had, a challenge we had, it was to try to unify our many arbitration courts into one international court. And this, I was so happy to see that the 4 important arbitration court in Madrid managed to negotiate and sign a very interesting, in fact, in the day of my birthday, the 18th December, if I am not mistaken, 2 years ago. And so now Madrid is proud, and that's why they have asked SCC to have a joint event. And Melanie was a very good choice. I mean, we had to pick up a lady in this case for the position of Secretary General of the MIAC, of the Madrid International Arbitration Court. And we are so happy that Melanie decided to drop her job at the time with one of the most important arbitration office in Madrid, which is a very admired firm from all of us, Fernandez Armesto. She left here. She left him. I'm sure he was very disappointed, but she joined MIAC. And so I am so happy that MIAC is going to be present all over, and every day is going to make them. So we will start with them, with the 2 of them. I will give the floor to Kristin. Then we will have Melanie, and I was asked for Melanie to explain to you if there are questions. It could be very easily asked. I would be grateful if you could ask the question through chat. And Melanie has promised me she will be able to speak, to follow the chat, and she will transmit to me. But we will have dialogue at the end of the 2 panels, to leave these 4 very prestigious panelists to have their time. And if there is time, we will ask more questions. So that's all. Thank you to Sweden. Thank you to Madrid. In Sweden, we are having, I think, our king and queen. So it's a very important moment. Yesterday they held a reception to the Spanish colony, and I remember all of them. They were very happy Spanish people living in Stockholm. Well, in Stockholm, some of them came from the south, from Helsingborg and Gothenburg. So I am sure it was quite a reception. Thank you to all of you, and Kristin, you have the floor.
Thank you, Javier, and thank you very much to the Madrid International Arbitration Center for this joint event with the SCC. Very excited to be doing this with you all. So thank you, Melanie. Thank you, Juan and Javier, for participating in this event today. Like Javier said, we have a limited time for our 2 panels. So without much further ado, I will try and share my presentation. And just nod if you can see what I'm presenting. Yes, it should be right. So, all right. So I have about 10 minutes to speak about the SCC, and I will quickly touch upon the history of SCC, what we're known for, and then dive into the innovations in arbitration that the SCC has been up to or come up with in the recent history. So The SCC, as you will know, is an old institution. Let me see if I can find my little arrow. Has been around for over 100 years. It was established in 1917. And today it is one of the leading international dispute resolution centers, and arguably the most modern one, not the youngest, it's quite old, but arguably the most modern one. We'll see when we've heard Melanie speak about the work at MIAC as well. But we see about 200 cases registered with the SSC per year. 50% of those cases are domestic arbitrations and 50% are international. And we see approximately 40 countries represented in our statistics every year. And the majority of those international cases have an East-West characteristic to the dispute. A lot of our cases come from the energy sector, and we also administer investment arbitrations. The majority of the cases or investment arbitrations administered at the SSC are done so under the SSC arbitration rules, but we also act as appointing authority under UNCITRAL rules. And to highlight the key features of the SSC is that it is indeed an internationally recognized institution. It is also impartial and independent from the state. It is the Stockholm Chamber of Commerce is a private organization. And over the years, the SSC has been acknowledged as a very innovative and forward-leaning institution with a strong focus on time and cost efficiency. So take a look at this particular slide where I've summed up some of the innovations that the SSC has delivered over the years, starting in the 90s with rules for expedited arbitration. We see a lot of expedited arbitrations at the SSC. I know it is also a very topical question to date, and very happy to have been a leader in that field as well. One of the innovations at the SSC we see both in terms of procedure and procedural rules and new innovations for embedded in our rules, but we also see innovations in terms of the administration, and there's where the digitalization comes in. For the past decade, we've had a strong focus on technology and using technology to enhance efficiency and expeditiousness in our caseload. And using the tools out there, we left the paper trail behind already in 2013 to move to a digital case management system. But the big leap happened in 2019 in this regard when we launched the SSC platform, which is a case management platform for the use of the institution, the parties, and the tribunal. It is a cyber-secure site or virtual room where the parties and the institution can communicate securely. Also, just to add, like Javier mentioned earlier, in terms of innovations, we recently launched a completely new dispute resolution tool called the SSC Express. I will, for the sake of time, not dive into this very exciting topic here and now, but would be happy to join you at another occasion to talk more about the SSC Express. But back to the SSC platform. So the SSC has had a long focus or a focus on digitalization, as I mentioned. When we knew for quite some time that this was something that we wanted to do. It had been on our list of priorities for a long time, but it didn't get to the top spot until in 2018, when we sat down to discuss what it is that we want to achieve and what features and what prerequisites were needed and how we could go about this. And we found that we had 4 main criteria for such a case management platform. And first, it had to be relevant to arbitration proceedings. It had to have all the features that would be required for administrating arbitration proceedings in an efficient way, and not very much else. There are a lot of different products out there, and we were very mindful of choosing a product that was not too busy. It was very important to have a simple interface and an easy look, an interface to meeting our users. And that has to do with user friendliness. It needed to be user friendly. It needed to be easily understood. It needed to cater for both the young and the old, and the tech savvy and the not so tech savvy people in our industry. That was very important. And of course, cybersecurity was another aspect that was highly important, as it was one of the main reasons why we wanted to achieve this in the first place. And fourthly, it needed to be included in the administrative fee of the institution, as we want our users to use the platform, and that was very important, that there was not going to be any other threshold or point of discussion for parties whether or not to use the platform for the administration of the case. So we achieved exactly that, and this is one of our sorry, I hear someone talking. Yes, so this is a sneak peek of what it would look like if you enter the SSC platform. It has the main functions. Melanie will recognize our platform from MIAC's platform and how it's built up. But this is the tool that we've used since September 2019, and very successfully so. We were lucky to launch it prior to the pandemic. It was, you know, very, very lucky, and a strange thing to be entering the pandemic, but with this already in place, which helped our cases a lot, and our case managers not to lose any speed in the case administration as such. We've seen we have more than 5,000 active participants in our cases. We've seen 500 cases registered on the platform since September 2019. Currently, we have 231 cases ongoing. Of the 5,500 or so users that we see in our cases, about 2,100 are unique users. So we have a lot of repeat customers in that sense. And it is possible to upload a lot of documents, but as an estimate or an average, we have about 2,000 files uploaded in each site or arbitration. So with this experience, and as I said, we were lucky to have this already in place when the pandemic hit in the spring of 2020. We did notice that our friends in the industry who were active in ad hoc arbitrations were struggling, in the sense that they did not have any support of any institution and found themselves in lockdown. So what we did was we teamed up with our supplier, which was Haiku, then later purchased by Thomson Reuters, to create the ad hoc platform. And this is a sister platform, which is basically a mirrored instance of the SSC platform, but it is available for ad hoc proceedings across the globe. So it has nothing to do with Sweden or the SSC. Other than that, we offer it to ad hoc proceedings as a cybersecure space for handling such cases. And as you can see, it has a very similar look to the SCC, but of course, there is no communication with the SCC, as we are not administrating any of those cases. That is very quickly about the digital innovations of late at the SCC, but I could also finish off by saying that I know that at least 15 other institutions are looking into developing their own platforms currently, which only tells us that this is the right path forward. This is where arbitration will be taking place to a great extent, with or without a pandemic. This is the path for arbitration going forward. And I'm happy to answer any questions or discuss further with Melanie after her presentation. Thank you very much.
Thank you, Kristin. Thank you to you. We are so happy to learn that from 1995, when you already used the word expedient arbitration, you have moved forward, and we are having now the SCC platform and the ad hoc platform. So congratulations for the good work done. And now I give the floor to Melanie, who I'm sure she has great ideas on her mind also. Thank you.
Thank you so much, Javier. Can you see my screen? Great, excellent. Well, thank you so much, Javier, for your very generous and kind words. And for me, it's an honor, for MIAC, it's an honor to be sharing this seminar with SCC. And thank you so much, Kristin, to share this first panel with me and MIAC. It's really an honor to have this long track record institution such as SCC. So thank you. As regard the MIAC, the Madrid International Arbitration Center started operating in January 2020. It is the result of the union of three important courts in Spain: the Madrid Court of Arbitration, the Spanish Court of Arbitration, and the Civil and Commercial Court of Arbitration. MIAC has also counts with the Madrid Bar Association as its strategic partner. So as you can see, and as Javier and Kristin mentioned, we are a very young institution. The mission of MIAC is to offer a service of the highest standard to resolve international commercial disputes in a time and cost efficient manner. So the institution monitors the case from the very beginning of the proceeding. So regarding, for example, regarding the appointment of arbitrator, MIAC encourages for the parties to appoint arbitrators. And if they fail to do so, then MIAC counts with an independent appointment committee, which carefully selects arbitrators. At the very end of the procedure, MIAC also counts with the committee that reviews the award prepared by the arbitrators to ensure the highest quality. So this committee, as you can see on the screen, comprises 24 external members appointed by the council. These are external members and are professionals of renowned prestige in the arbitration community. They're fully independent from MIAC, and they receive no remuneration for their task. So MIAC was born in a digital era. We all know that the 21st century has shifted from the Industrial Revolution to the command of information technology, where digital technologies such as cloud computing, mobile devices, virtual reality play a prominent role in shaping up the behavior of societies, of organization, and of individuals. And of course, arbitration is no exception. So when we started MIAC and when we were brainstorming about what kind of institution we wanted, what were the best practices, what would our culture be as an institution, as an arbitral institution, what were our purposes, we knew that the use of technology had to be one of our priorities. Being a 21st century arbitration institution, MIAC strives for efficiency using technology. And this, I think we can see it, or we can witness it in two different levels. First, in our offices, and second, in the case management. So regarding our offices, I remember like 10 years ago, I read a book that was written by Bill Gates and Colin Hemingways, and it was titled Business at the Speed of Thought. And you probably know this book. Basically, they give insight on how to integrate business processes with technology, and they explain how advances in information technology can make a difference in a day-to-day business. And one example of that was the paperless office. So I thought at that time, 10 years ago, I thought it was really a chimera, right? But nowadays we can see that this has become a palpable reality. We actually, if you think about it, we don't use paper letters anymore. We use emails. We don't use paper agendas anymore. We use Outlook calendars, at least for most of us. And I actually almost never use my handwriting anymore. So almost everything can be done through digital devices, which has considerably reduced the need for paper. In our office, at MIAC specifically, I can use my task as an example. All my meetings are, almost every meeting that I have is virtual, because whenever I have to meet with my team, it's virtual because every single responsible is in the different courts that compose MIAC, as I mentioned. Every time I have a meeting with the commission that appoints arbitrators, it is a virtual meeting because they are, one is in Portugal, the other one is in the United States, etc. Every time I meet with the members of the Commission of Scrutiny, they would be anywhere in the world. So most of our meetings are virtual. And this actually, probably the best example that I can give is that I carry my office in my purse every day because I just need my computer, my cell phone, and a good internet access. So this speaks volumes about how we can use technology to work. We have also used a lot the QR codes for business cards, for example. Many of you, at least on my side, I would use the QRs that are in the LinkedIn. So every time I need to give my information, I would go to the LinkedIn and I would show my QR, and you can add me to your LinkedIn profile. And so that means that I don't need to use paper anymore. If I speak, for example, about flyers, and on the screen you can see the QR code, and I will let it there just for you to, if you have a cell phone, you can go into that QR and you can go directly to our flyer. So this has been some resources, technological resources that we have been using in MIAC on the office level, as I mentioned. Now, regarding the case management, we try to reduce at its minimum the use of paper in the proceedings. So most of our communication, almost all our communications are digital except for rare occasions or exceptions. We have, of course, used virtual hearings. We have a protocol for virtual hearings, and of course, the digital platform to handle proceedings. So actually, international arbitration was not unfamiliar to digital technologies, but we can all agree that not many institutions made good use of this technology before COVID-19. So COVID-19 has really accelerated this fourth industrial revolution, and now the most important institutions have caught up with digital technologies. So the bad news for MIAC is that it could not be as innovator or disruptive as we wanted. We can say that actually the pandemic has stolen MIAC's thunder. Nonetheless, every cloud has a silver lining, and I can mention two positive aspects. The first one is that this has encouraged the institution to work harder to compete in a very demanding field. And the second aspect that I can mention that is positive is that the arbitration community has been amazing adapting to the new conditions, the post-COVID conditions. So the pandemic has taught us to be flexible and adaptable, and I think that is very good news for the arbitration field. So let's go to the digital platform. Actually, MIAC has the same platform of SCC. This is the HiQ Thomson Reuters platform, which provides a secure digital environment where the participants and all the participants of an arbitration proceeding can exchange communication and store the evidence and the file of their proceedings. When we started looking for different platforms, we thought this one really accommodated to our users' needs, and it gave what gave us a strong green light, let's say like that, was that such a prestigious institution such as the SCC already had it in place. They were actually pioneers, I think, in this field. So I would not go into the details of the platform because, of course, Kristin has already mentioned it. But what we were looking for in MIAC is to have a user-friendly platform, to show it in an efficient and practical and useful way. So what basically our experience with this platform has been very good. I have to admit that actually we're, as I mentioned, MIAC is a very young institution. We have reached the 10th case, so we only have 10 cases, but all our cases have been administered through the platform. So most of the cases have been, we didn't have any problem with the parties or with the tribunal. We have some exceptions, and very honestly, I think that there are some parties still, or some arbitrators even, that are reluctant to use the platform. There is still a little resistance to change. So I can see that in one of our cases, at least. The rest, I think it has been flawless, but in one of our cases, I've seen that they use a platform, they would upload all the communications, but they will still be sending the communications through email. So I think we have to be, as an institution, let's call it technical evangelists, and try to put on many best practices to make users at ease with the platform. So what we have done so far is, first of all, what we do is that every time a case starts, we have a phone call with all the participants to set up the profile and to explain how the platform works. We have included a guideline too, for every user or every party or members of the tribunal to be very clear on how the platform works and to help them if they have any problem with the platform. And of course, you have the contact details of the case managers in case you have any questions regarding the platform. So at the end is a matter, I think, of building trust. And I'm just going to finish with this. I'm going to show you very quickly how the platform works. So actually what we do here is on the first page, we will show who is the claimant, who is the respondent, and the main characteristics or the main features of the arbitration. So any party can log in into their case, and they can see those characteristics very quickly. So this helps a lot with efficiency. And this is the chronology of the procedure. This is another item that I would love to mention, is that we have to give predictability and certainty to the users. So actually this procedural chronology, what gives us is that they already know what happened in the procedure, where do we stand right now, and where are we going. So if you look at the very end, you will see, and in orange letters, we always have next steps. So next steps, not only in the platform, but next steps in every of our communications, we have the next steps. So this allows the parties to know what has happened in the case, where are we, and what's going to happen in the case. And this, I think, gives a lot of predictability and certainty. So if a party, for example, cannot reach its counsel, its lawyer, it can just go through the platform and have all the information of the case, and have this predictability or certainty that I think users need. And then we have, of course, a section where you have the claimants, the respondents, the arbitral tribunal, and the people that is working in your case. So there's really a closeness to the user. You know who is behind the institution. And of course, you have the contact details, because there's nothing worse than trying to contact someone, looking on the webpage, there's no phone, there's no email, you don't know what's happening with your case. So actually, I think these are little tips that will help the users to be confident that what's happening in the procedure, and if they have any question, just call or send an email. So basically, just to finish, I think that to build this trust, like this platform really has helped us to build this trust, and we're still working on that. And I think you get trust with time and cost efficiency, predictability and certainty, and of course, accessibility and closeness to the user. So this is all for me. Thank you so much.
Thank you very much, Melanie. Thanks a lot. I think Jose Antonio Caín, whom I am replacing, will be very happy with your presentation, because you have insisted on his most important point of trying to have MIAC as a very technological and advanced arbitration center. So I'm sure you both will be strengthening cooperation between Madrid and Sweden on the issue, because out of Kristin's experience and your enthusiasm about this. In fact, I was coming today in the morning from a meeting where I was listening again. As you know, we have problem with justice in Spain, in the sense that it is almost blocked because of the pandemic. Unfortunately, international arbitration in Spain is doing well. It's quite technologically, it's as good as could be some other centers all over the world. Unfortunately, I learned that on the contrary, domestic arbitration in Spain was not so technologically advanced. On the contrary, as Kristin has explained to us, fortunately, SCC is working both 50-50 with domestic and international arbitration, which is something I am sure Jose Antonio, the president of MIAC, is dreaming of. So thank you to you, both of you, and I will.
Javier, sorry for interrupting, but maybe I can give you a piece of information about this regarding the national arbitration. We actually all our courts, the founding courts, have adopted this system too. So this is a very good news, because it's not only
very good news. Thanks a lot.
But also the four courts that
I'm happy you are following a Stockholm example. I'm so happy. No, just I'm going to move forward to the second panel. We have more or less the same time. I really want to praise and thank Juan Ignacio presence here. I mean, I am just, as you know, I'm just almost a student. I mean, a very veteran student of arbitration, and I remember I have listened to him in several past occasions. In fact, I have in front of me when I attended a very interesting meeting, renewable energy and investment arbitration. That was February 21. And he was sharing the floor with Eduardo Silva, with Ricardo Ampuero, with Deva Villanua, who are perhaps three of the best known names together with him in what would say the in-house arbitration world. And so he's quite an expert. In fact, he has a quality which is not so common in the legal world. He is very, very, very coherent. I mean, he has almost spent 34 years with Uría. How many years have you been? Well, I know you are very young, but I mean, you started in 98, no? So one of our best legal office in Spain is Uría, and he has been a partner. I mean, 10 years after he joined it, but he has been a partner for many years. And he has devoted really most of his many hours of work to investment arbitration. So I'm sure that he will tell us interesting things. I will remind him that Spain has been a defendant most of the time. And then we have, thanks to Kristin, we have a legal expert who is from SCC. And I read, in fact, that he has been started young. He's almost very young, but he started as a clerk with the law clerk at the district court. I remember when I was asked after coming back from Sweden by a friend who was an arbitrator, Javier, could you translate to me Svea? I was very happy because I had no idea which level of judicial court was Svea. But then I learned. And now I know that since you are coming from this area, judicial area, Christoffer, you know, and you will tell us many things about this dispute, energy dispute. So thanks to both of you. And I will give the floor to Juan Ignacio, and then we will listen to you. And if we have time, we will have some questions and answers. Thank you very much. Juan Ignacio.
Perfect. Yeah, thank you so much, Javier, for your introduction. I hate to be a party popper, but my job, frankly, is trying to avoid that we need to use either court of arbitration. I mean, my job is precisely trying to get parties to agree on contracts, on transactions, and trying to avoid litigation. But, you know, obviously we are aware of facts, and as much as we'd like things to move nicely, you know, we have to realize that fights, problems, disputes arise no matter what the lawyers do. And of course, as lawyer, as a practitioner, I want to believe that we do our utmost to try to avoid going to arbitration and litigation. But in my particular area of expertise, energy, disputes are bound to happen, unfortunately. And there are several reasons for that. And I'll try in my slide to deal and to give a very summary overview as to why it is the case. This is a typical energy project structure that you can't easily find in the internet. This is the archetypical, simplified structure of a large energy project. You are bound to have, you know, the different parties, which I've tried to underline with a gray color, almost the outer circle, and you have contracts, again, in a simplified fashion, in green in the inner circle. One thing that is common to many of the energy projects, or in fact, 5 features that are common to energy projects are set out in that column on the right hand of the screen. First feature is, of course, that these are capital intensive projects. So there's loads of capital involved. So therefore, the potential for disputes is huge. I mean, you're not talking typically peanuts, you're talking millions, euros, dollars, whatever. So the potential for conflicts is, of course, there. But energy is also a very international area of business. It is very, very common that energy projects will involve different countries, either because you know, the projects themselves are located, or there are inputs coming from different countries. Just think of a power station where gas may be coming from all over the world or from particular jurisdictions, and even a power station may be selling electricity to different or in different markets, or certainly to parties from different backgrounds. So there are different contracts, different parties, international parties, and again, in many of these projects, of course, contracts have a long-term duration, be it construction contract, be it the supply contract, be it the PPA, or just the hedging agreements in place, you name it. There's bound to be contracts that will stand for several years. So again, the potential for conflict, as needless to say, increases year on year. And finally, but not by any means the list of our concerns, this is typically a highly regulated environment. Energy in any market, in any country, is a highly regulated environment where you have different layers of authorities, be it because they are competent for building permits, or be it for in industry permits for operation, or at the end of the day, by governments from the countries involved. And of course, governments, as we all know, particularly in this country, in Spain, they do have an important role to play. They can interfere, and they can become themselves the subjects of many claims and disputes. So energy, unfortunately, is probably one of the, I'm sure Christoffer will give us the data later on SCC, record of disputes, but energy is, of course, bound to be one of the most popular sources of disputes in any international arbitration environment. So which are the features, though, the considerations that I put in this slide will play a role when we are advising parties in agreements, and either we have to provide our input or our views as to should we go for arbitration or go for jurisdiction process. And typically, again, as you can imagine, I'm sure you've come across these before, these clauses tend to be at the very end of the contract. So by the time you get there, you spend hours on end disputing and fighting every single corner of the contract. And gosh, here comes the arbitration versus jurisdiction process. And that's the very first hurdle that you have to overcome. Should we go for arbitration? Should we go for jurisdiction? If we go for arbitration, which system, which institution, which proceedings shall we use? So when approaching these issues, definitely the first one, to be honest, in my mind, has always been the complexity of contracts. The more complex the contract is, the higher the chances are, I would say, let's go for arbitration. And in this industry, contracts tend to be horribly complicated, not only because a contract in itself, long-term supply agreements, EPC contracts, all of them are enormously complex, but they are even more complex if you need to put them in a framework where you are looking into an energy project and you have to take into account the interests or the interface of different contracts and different parties. So clearly, say, go for local courts, local judges, unless they are really people who have first-hand expertise in this industry. It's hard to say or hard to recommend a client. Well, yeah, you can certainly go to a court because the judges will understand these contracts and will, of course, be familiar with intricacies of these contracts in the context of a large energy project. So clearly, point one for arbitration, needless to say. Secondly, different jurisdictions involved. We said earlier that energy projects tend to be very international. Every counterparty that you'll come across will, of course, try to argue for their own laws, and needless to say, even if they lose that battle, they'll try stick to particularly if the project is located in any particular country, because of power station or facilities that are to be built in that particular country. Of course, the sponsors will fight their corner trying to argue for local courts. Needless to say, if you are operating in emerging markets, more frequently than not, you'll have an easy point trying to argue out of the jurisdiction of local courts. Sometimes, needless to say, there are issues and there are matters that you can't avoid having the local courts adjudicate on those matters. But to the extent that you do have some room, that you do have some choice, you'll try to walk your way out of the use of local courts. And as I said, unfortunately, but this is a fact, there's no judgmental opinion here, is that there's a flight from local jurisdiction in emerging markets to international arbitration. Thirdly, language. Language is an issue, and is an important issue when you are confronting the choice between arbitration and tribunals. Most of these countries, most of these contracts these days are negotiated and drafted in English. Right or wrong, is the international, it's the language for international business. And in most cases, and certainly my experience, even if you are pursuing an energy project in Spain, you're bound to have contracts that are drafted in English and negotiated in English, even if the governing law, is Spanish law. So you have negotiated, drafted these contracts very, very carefully, and parties will have spent hours looking into every sentence, every word that is used. And of course, the last thing you want to do is to have those contracts submitted to someone, to a court in Madrid, say, again, no, no negative connotations here, but to a judge who's probably not extremely used, let's put it that way, politely, to review contracts in English and to use legal English in analyzing the conflicts, in analyzing solutions, and even drafting its own judgment. So at least in this country, unfortunately, courts need contracts to be translated. And let's say, in Italian, I think it is, traduttore traditore. So translator is a traitor. And of course, there's always bound to go off some shade of color, no matter what, no matter how good your translation is, something gets lost in the process. So again, another reason for arguing for arbitration. Then, needless to say, you are seeking protection from local governments, and not only in emerging markets, or you may have to seek that protection, not only in emerging markets. And again, unfortunately, in this country, in Spain, we do have not tremendously successful track record of avoiding international arbitration from investors complaining against the Kingdom of Spain. So BIT, bilateral international treaties, or international treaties such as the European Chart, the Energy Chart Treaty, those will come to the fore very quickly. And as you know, the issues of fair treatment, non-discrimination, no undue expropriation will come to the top of our minds. So again, their investors will look carefully whether to pursue their action in local courts or whether to go for international arbitration. An important consideration as well when you are looking into this, late hour discussions as to whether we go for arbitration or courts is confidentiality, and is one of the features that I like the most about arbitration. That is confidential, and you go to war when you are in arbitration, but at least that war is kept under a blanket and it's confidential. The market will not get to know what's going on, well, most of the time, and the details, the dispute itself will be kept confidential, and that is absolutely key. You could argue that the same happens in many courts, but frankly, experience shows that that is not the case in most cases, in most of our experiences. Expediency of proceedings, needless to say, comes to the fore, and sometimes, parties may have different views and different interests here. Some parties may actually like proceedings to go on for years and years. But, if you have business-minded people, go for some expediency, some, having a sort of, and we all know that international arbitration, deadlines are flexible and sometimes are difficult to control. But boy, they're far more approachable, far more reliant than if you are in the hands of courts. Again, also judging and coming from our local experience in many of the countries where we operate, where, of course, duration of proceedings is an issue, and it's something that you need a quick solution in many of the disputes when you are developing, constructing, or operating an energy project. And finally, once you've made your point as to, you've parties to an agreement have reached the consensus that we should go for international arbitration, then there is the issue, okay, well, but then which court do we use? And what what Kristin and Melanie have just explained before me is absolutely nice, and I'm delighted to hear how expedient, how easy these proceedings are, how the rules, how convenient both set of proceedings are for practitioners and for parties. But I think we also look at some of the elements that I've just outlined there. It's a track record of international institutions, and we look at the reputation, of course, availability of experts, the rules. Well, the established rules are reliable rules, and rules are known to practitioner. Costs, needless to say, it does play a role, and location. And as you know, again, one of the most heated debates ever when you come to these clauses is where the seat of arbitration needs to be, and you'll spend, again, hours on end trying to come to an agreement on location. And finally, overall, the market acceptance of the institutions. So clearly, SCC and MIAC growingly on some of the courts that Melanie was referring to as founding courts of arbitration for MIAC are venues and institutions that we have used and are very well known in many of the international arbitration cases that we have been involved in. So those institutions, I'm sure, will be top of our list when we come to negotiate these clauses again in any of our deals shortly. So without further ado, I'll give the floor to Christoffer so that he can give us the views from the SCC when it comes to these disputes in the energy field. Christoffer.
Thank you, Juan Ignacio. Thanks a lot. I enjoy very much your English. It seems you're many years in London. Have done a lot. I enjoy to see a Spanish lawyer with a certain common law approach. So I was happy. Your presentation was very good. And now I give the floor to Christoffer. And since he's the younger, I will ask him to try to make a little shorter his presentation, just to have some minutes for to try to answer some of the questions. But before that, I want to mention that he's a young practitioner, but he has picked up two areas where he has a big future, a great future. He's an expert in criminal arbitration, which I think he made a very good choice. And then he's also very active in the search committee of the Equal Representation in Arbitration pledge, something I learned recently, and I have understood that it plays quite an important role. In fact, I listened to a Spanish colleague of yours, Elena Gutierrez, who is now an arbitrator in Paris, and recently I listened to her speaking about this pledge, which is very important. So this seems that you will have a great future, I'm sure. And so you have the floor, and you try to make it a little shorter to have Melanie to help us to ask some questions and try to answer. Thank you very much, Christoffer. The floor is yours.
Thank you very much, Javier, and thank you very much for that kind introduction. And thank you, Juan, for opening up this panel with some very interesting and insightful points. I have a presentation as well. I will try to keep it a bit shorter as per your request, Javier, but I will try to share the presentation as a start. Can you see it now? Yes.
You might want to put it in display mode.
Oh, is it not in display mode?
No.
Oh. Yeah, let's see.
You can stop sharing and try again.
Yeah, let's do that. As always. So now it should be in display mode. All right. So what
I'm sure that's okay. You can go
yeah,
on.
you're seeing the slides at least. I think that's the important part. Okay.
That is right.
Yeah, that's good.
Go on.
Perfect. Thank you. So thank you again, Juan, for opening up the floor. I think what I will be saying will be tying in with what you said as well, to some degree. But what I will try to do is to share the institutional perspective and of course, specifically the perspective of the SCC on energy disputes. And by way of sort of a general background, and as Kristin mentioned, energy disputes have formed a very important part of the SCC caseload for a very long time. And I would also dare to say that this probably holds true for a lot of major arbitral institutions as well. Because in fact, energy arbitrations is commonly referred to as one of the fields that have contributed most to the growth of arbitration and international arbitration as a form of international dispute resolution. And as Juan mentioned, arbitration is indeed oftentimes a very suitable form for dispute resolution for energy disputes due to the complexities and the size of the disputes. But besides from the energy sector being an important driver for arbitration historically, it is likely that energy disputes will continue to be important for arbitration and arbitral institutions for the foreseeable future. Because what we see is that the energy sector is constantly growing due to a steady global demand for electricity, which is caused by a growth of the global population, growing economies, and technological advances. And I think that the energy sector is and will continue to be an important driver for arbitration and for institutions, not only because they represent a big part of the caseload of arbitral institutions, but also because as we have mentioned, the amount in dispute will usually be quite high due to energy projects being capital intensive and also very complex. But proceeding then to look at the role that arbitral institutions such as the SCC play in regards to energy disputes, the overall mission of the SCC is to facilitate trade and business by providing a neutral venue for dispute resolution, by providing tools that fits the developing needs of the business community. And keeping this overarching objective of the SCC in mind, the importance of a well-functioning energy sector really cannot be overstated. Because of course, access to energy, it says itself really, is of course crucial in our modern world and a requirement to keep our modern society running and keeping our light bulbs lit. And I do believe that arbitration and institutions have an important role to play when it comes to facilitating business, trade, and investments in this particular sector. And another aspect that needs to be considered when examining the role of arbitration and arbitral institutions in the energy sector is, of course, climate change and the transition to renewable energy. Because at the same time as the demand for electricity is increasing globally, there is, of course, a pressing change or pressing need for change of the way that energy is produced and also consumed. So in this regard, we can see that arbitration plays a role in contributing to the sustainable development objectives by providing an appropriate venue to resolve green technology and in particular renewable energy disputes. So from this sort of general background, I think that it follows directly that an important task of the SCC and also other arbitral institutions when it comes to energy disputes is to provide rules and institutional frameworks which work well for energy disputes and makes it possible to resolve these disputes in an efficient and expeditious manner. But before looking to how institutional tools and rules can do that, I think that it could be of interest to have a look at the SCC caseload to see what kinds of energy disputes we see and to what extent. So then I'm trying to proceed to a new slide, and I hope that this screen changed for you as well. It didn't?
Not yet.
Yeah.
Not yet.
Let's see. Let me try to share that again then. Let's see if...
You might want to put it in slide mode before you start sharing, and then you can pick the window. There
Maybe,
you go.
Is this better?
Yes, much better.
Perfect. So then I will proceed. So first off, looking to the causes of the energy disputes administered by the SCC, I believe that these can be quite generally sorted into the categories that we see on this slide. So first off, we have pricing disputes, which will often be a bit different from regular disputes because they are perhaps not as adversarial at the outset as many other forms of disputes. They will often be concerned with whether a trigger event has occurred that actualizes price revision. Then we have disputes concerning non-payment, which of course are a bit more similar to other commercial arbitrations, and it goes for both pricing and non-payments disputes that these will usually be seen in commercial cases rather than investment cases. But proceeding to the second category, we have disputes which fall within the realm of investment disputes, and these are disputes caused by, for example, regulatory changes such as alleged elimination of incentive schemes or increased taxation by a state. And one thing that might be especially interesting to note here is that the SCC is actually one of the 3 possible forms appointed in the Energy Charter Treaty for investment disputes under the ECT. Then the third category on this slide is that we have disputes arising out of a failure or alleged failure to cooperate under a complex energy agreement. And in this broad category, we often find energy disputes of a more general contractual nature. And this can concern, for example, failed deliveries and other contractual disputes. Proceeding to look at some data and numbers here and looking closer on what types of cases we see in the SCC caseload. On this slide, we see the proportions really of the types of energy cases that we have seen in the caseload since 2001. And what we see on this slide is that the majority of cases are contract-based energy disputes. So that is cases not based on investment protection treaties, but rather on commercial contracts. Then we have about 15% of the cases being either cases based on the Energy Charter Treaty or brought by investors under bilateral investment treaties. And continuing on the track of statistics, we see on this slide which particular energy industry segment that our cases have concerned, once again since 2001. And what we will usually see, because of course these proportions changes from year to year, but what we will usually see is that oil, gas, and electricity related disputes tend to be represented in the approximate same proportions. Perhaps as you can see on this slide with a slight inclination to gas disputes. And then we have a smaller segment with where other industries are involved. So as you have seen and gathered from these slides, the SCC has gotten quite accustomed to administrating energy disputes over the years. So the next logical question then becomes, what have we learned from this administration? And on this slide, I have tried to list some of the main features that we can usually discern in the energy cases that we see in our caseload. And these factors, I think, ties in quite well with what Juan said earlier in his presentation and his observations of the characteristics of energy disputes. Because first off, we see that there is usually a high amount in dispute involved due to energy projects being big in scale, capital intensive, and as you saw on Juan's slide, also quite complex in a lot of cases. Due to the scale and value involved in the energy projects, you also see that the cases are complex, as I mentioned, which is then associated with big volumes of documentations. And this is both in terms of party submissions and in terms of evidence, which is oftentimes quite technical as well. On the same theme, we can also see that, as Juan also mentioned, that usually the subject matter in dispute will involve quite long-term contracts or agreements, which oftentimes adds to the complexity as well. And I would say that the main lesson that can be drawn by arbitral institutions here is to have a well-developed institutional framework. And one part of this is to have rules that can really accommodate the procedural complexities that follows from the complex and often technical nature of energy disputes, and also to have a strong institutional practice of applying those rules. And a clear example of this type of rules can be rules regarding, for example, consolidation of cases, joinder of the third parties, and whether claims brought under multiple agreements shall be allowed to proceed in a single arbitration. Because rules such as this really allows the institutional practice to reflect the reality of energy cases, which will oftentimes include multi-party elements. Another aspect, or another example, might be rules concerning the use of technical experts. The second part of having a well-developed institutional framework is to have a case administration in place, which allows for the efficient and expeditious administration of large and complex disputes. And I think that the clearest and best example of this, which I also see in my daily work at the SCC, is the usage of the SCC platform, because this is the tool which really makes it easier for the parties, the tribunal, and the SCC to handle large volumes of documentation in a safe and reliable manner. And having a common case file which grants an oversight on the dispute, I think the value of that can hardly be overstated. So those are some takeaways, and being conscious of the time, I am approaching the last slide here of my presentation, because I noticed in the invitation to this event that we were also asked to talk a bit about trends in energy arbitration. And I think that one trend that is quite safe to speculate in, and which I have already touched upon a bit, is dispute concerning green technology, and in this context, specifically renewable or green energy. And I think that this is a sector that arbitration and arbitral institutions will be seeing more of. To dive a bit deeper in this subject, still being conscious of the time, I just wanted to mention that the SCC has actually published a report in 2019, which is written by one of our previous legal counsel concerning green technology disputes at the SCC. And I think that that report might be of interest to the participants in this webinar. The scope in that report was a bit broader, since it examined green technology disputes and not only energy disputes. But to summarize some of the findings which might be of interest in this webinar, the report first looked at SCC commercial cases, which were initiated between 2014 and 2018, and found that in the green technology cases registered during that period, 61% of the parties pursued activities in the renewable energy sector. In those cases, we saw that the claims mostly concerned damages for non-delivery and also failure to pay for delivery. And it included both technical disputes, such as a case concerning software systems relating to wind turbines, and non-technical disputes, such as unpaid deliveries of components to wind power structures. What we saw here was also that the report confirmed what has already been said a few times during our respective presentations. The amount in dispute was quite high in the commercial cases. The average was 14 million euros. And then the report also looked at investment treaty disputes, where the investor had an investment in the green technology sector in the host state's territory. And what we saw in those cases was that 14 out of 16 cases concerned investments in solar power, while the other 2 concerned investments in wind energy. And in these cases, the amount in dispute was on average even higher, amounting to an average of 88 million euros. So I think, being mindful of the time, that I will stop there and open up the panel and the floor for further discussions. Thank you very much for listening.
Thank you, Christopher. Thanks a lot for everything you have told us, especially for the effort you have made on the statistics. In fact, I was quite impressed by this from 2001. I mean, you have offered us some interesting statistics. I'm sure that Melanie, who has been working at the same time, who has been listening to you, and I have seen she has sent us some of the links we need to follow your explanation. So thank you very much. And before taking back the floor, I will ask Melanie if she would like to have some questions. I give you the floor, and then at the end, I might have, if I have time, I'll make one or 2 questions. But you have the floor first, Melanie.
Yes, Since we said this seminar was going to last an hour, we don't have that much time, but I'm happy to inform that we have answered all the questions in the QR chat. So no questions that we need to address for now.
Congratulations. So I will tell you, I will say the final word. I will again apologize for José Antonio Caínzos, the chairman of the MIAC, not being present, and I will thank him for not being present, because thanks to that, I have been with you. If not, I would have been just one more follower. And my 2 points will be asked first, Kristin and Melanie, to work on future cooperation projects. And I hope one of them brings Kristin to Madrid or Melanie to Stockholm. That will be, as an ambassador, will be so happy that these links strengthen more and more. And secondly, I will ask Christoffer also and Juan to try to work together, because Spain, as Juan Ignacio knows better than I do, has been quite, I mean, not suffering, but we have been very active in energy cases, as you well know. And I have seen that Christoffer has a very large knowledge of what this area offers us. So I'm sure out of this today's webinar, I think we are starting a period of cooperation between MIAC and SCC, and you count on me for anything you might need. I mean, as you know, I'm just a retired diplomat. So, but anyway, I will be very happy to be able to see you both again in some other event. Thanks a lot, and Melanie, especially to you and to your team, to Mariano, because I think it has worked technological. Kristin has learned a lot, because the other time she was telling us she didn't know how to move and now she's teaching Christoffer how to do this. So congratulations, you have done a wonderful job. Thanks a lot. If you have anything more to say, you say it, and it's not, farewell for all you. Thank you.
Thank you so much.
Thank you, everyone. Thank you.
Thank you very much.
Bye.
Bye.